My name is Ethan Tran. I'm 34 years old, and until a few months ago, I thought I finally understood the game of corporate life. Not mastered it, nobody ever truly masters it, but I knew the rules well enough to keep winning. For 6 years, I poured everything I had into a tech startup called VaultForge, headquartered in Austin, Texas. We weren't Silicon Valley glitzy, no billion-dollar valuations splashed across headlines. We were the quiet kind of company, building infrastructure software that kept supply chains humming and factories moving. Unsexy work, but essential. I started as a product manager on $75,000 a year. By the time I was 32, I was head of product, making a steady $165,000 base plus bonuses and stock units. I wasn't rich, but I was proud. I'd earned every promotion by grinding through late nights and endless investor demos. In March of 2024, everything shifted. VaultForge announced it had agreed to be acquired by a global conglomerate, Arcadia Dynamics, for an all-cash and stock deal worth $1.8 billion. For me, that number wasn't abstract. It was personal, because tucked into my employment contract was a clause I knew by heart. Section 7.3, Change of Control Acceleration. It meant that if the company was sold, and if I was terminated without cause or forced into a diminished role, my unvested stock would immediately vest. At current valuations, that was roughly $4.2 million. I remembered fighting for that clause 18 months earlier, in a tense boardroom with VaultForge's founder. At the time, some executives rolled their eyes. "Ethan, why are you so obsessed with legal language?" they laughed. But I'd insisted. In startups, paper is everything. I didn't know then that clause would become both the weapon and the battlefield. The summer leading up to the acquisition felt electric. Everyone was buzzing about what they'd do after the deal closed. Some dreamed of early retirement, others of starting new companies. I kept my head down. I had a young daughter, Lena, and all I wanted was stability. But behind the scenes, Arcadia's new executive team had different ideas. 2 weeks before the merger date, HR called me into a conference room. The woman waiting inside wasn't our usual HR manager. She was from Arcadia, dressed in a slate-gray suit, expression unreadable. Next to her sat our founder, eyes fixed on the table. "Ethan," she began, voice clinical. "As of today, your position has been eliminated as part of organizational restructuring. You'll receive a severance package equal to 3 months' salary. Please return your badge and laptop by close of business." I blinked. Eliminated? 2 weeks before close? She didn't flinch. "Your role is redundant under Arcadia's structure. You're free to pursue opportunities elsewhere." I looked at my founder. He wouldn't meet my gaze. I knew what this was. They wanted to fire me before the deal closed, before my stock acceleration triggered. I walked out of that building in a daze. 6 years of loyalty, 12-hour days, countless product launches, and they cut me like dead weight. But as the Texas sun burned my face in the parking lot, the daze cleared. I wasn't just an employee. I was the guy who'd insisted on Section 7.3. And I'd kept every version of my contracts, every email about vesting, every board minute mentioning acceleration. They thought I'd roll over. They had no idea who they'd just fired. That night, In my small apartment off South Congress, I spread documents across the kitchen table. Offer letters, stock grant notices, equity statements. I opened my laptop and pulled up the retention agreement Arcadia's HR had emailed 3 months ago. I remembered the pressure to sign. Everyone has to agree, Ethan, or the deal might fall apart. Buried in the legalese was a non-compete clause so broad it bordered on absurd. I couldn't work in any technology field related to data, software, or systems for 2 years across the entire United States. I chuckled bitterly. That alone was unenforceable under Texas law, and they knew it, but they were counting on fear. Most people see legal jargon and freeze, not me. I thought of my father, an immigrant who'd worked 60 hours a week in a mechanic's shop and told me as a boy, "The world will try to cheat you with words, son. Learn their language, and they can't touch you." So I read, I highlighted, and when the clock struck midnight, I sent one email. Subject: Representation Inquiry. Employment Termination before M&A. Recipient: Marisol Vega, attorney at law. Marisol's office was in a modest brick building near the Travis County Courthouse. No glossy lobby, no intimidating receptionist. Just a brass plaque and the smell of strong coffee. She shook my hand firmly. "Ethan, I read your email. Let's talk." For 2 hours I walked her through everything. The acceleration clause, the retention agreement, the timing of my termination. She asked sharp, surgical questions, jotting notes in neat cursive. When I finished, she leaned back. "Classic pre-close purge," she said. "They cut you so you wouldn't vest. Happens more often than people think. But you may have something solid. Show me the contracts." I handed her my binder. She flipped pages quickly, eyes narrowing. Then she stopped, tapped section 7.3 with her pen. "This," she said, "is gold. Change of control acceleration, triggered by termination without cause within 12 months of acquisition. That's exactly your case." My pulse quickened. "So I can fight this?" She smiled. "Not just fight. If we play it right, we can win. But they'll come after you hard. Arcadia has deep pockets. Their general counsel is known for bullying employees into silence." "I'm not looking for a fight," I said quietly. "I just want justice. What's mine?" Marisol nodded. "Then we'll give them a fight they won't forget." The next days blurred into strategy. Marisol drafted a litigation hold letter demanding Arcadia preserve all records related to my employment and termination. She explained, if they delete or alter documents now, it's spoliation. Judges hate that I still had access to my personal email, where HR had accidentally copied me on a draft memo about headcount reduction to minimize vesting liabilities. The phrasing alone made Marisol whistle. "They basically admitted it in writing," she said. "This isn't just wrongful termination. It's securities fraud if they failed to disclose liabilities to shareholders." A slow, cold satisfaction bloomed in my chest. They hadn't just fired me. They'd made me dangerous. But the real turning point came 1 week later. A friend still at Voltforge called me in hushed tones. Ethan, I don't know if this helps, but the board minutes from last quarter mention you by name. Something about accelerating equity if you're terminated. My heart pounded. Can you get me a copy? He hesitated. I'll try. Just be careful. The file landed in my inbox at 2 a.m. Board minutes, September 14th, 2024. There it was, in black and white. Discussion regarding change of control, acceleration provisions for key employees. Ethan Tran advocated strongly for clause inclusion. Motion carried unanimously. They had documented my fight for that clause. They couldn't pretend it didn't exist. I stared at the screen, adrenaline rushing. For the first time since being fired, I felt something stronger than rage. I felt inevitability. They thought they'd ended my story, but in truth, they had just written the opening chapter. Marisol moved fast. Within 48 hours, she'd filed a formal demand letter to Arcadia's general counsel. It outlined my claim: wrongful termination designed to avoid contractual vesting obligations, a breach of both my employment agreement and Texas state labor law. The letter was clinical, precise. Dates, clauses, exhibits. At the bottom, one line in bold: my client reserves all rights to pursue remedies in state court, federal court, and via regulatory complaint to the Securities and Exchange Commission. It was the kind of threat Arcadia wasn't used to seeing from a single mid-level manager. Their response came 2 days later in the form of a thick envelope couriered to Marisol's office. Inside, a 20-page demand for arbitration, signed by Arcadia's in-house counsel, a man named Richard Ellison. Ellison had a reputation in Austin's legal circles. Former Wall Street lawyer, sharp as glass, arrogant as hell. He believed no employee could stand up to his kind of pressure. Marisol scanned the document, smirked, and slid it across the table to me. They want arbitration, she said. Private. No jury, no press, and, most importantly, no shareholders finding out they're gaming their workforce to save a few million in equity. She leaned forward. Ethan, here's the thing. Arbitration clauses can be enforced, but not always. Texas courts have carved out exceptions when the terms are unconscionable. And this non-compete they saddled you with? It's so overbroad it actually helps us, I nodded slowly. My anger was still raw, but now it was sharpened into purpose. So we fight the arbitration demand. Exactly, she said. We file in Travis County Court. Argue the arbitration clause is void because it effectively strips you of your statutory rights. If we win that, we're in open court. And Arcadia hates sunlight. The weeks that followed were a blur of discovery. We subpoenaed documents, payroll logs, termination emails, board minutes, SEC filings. Arcadia resisted at every step, burying us in objections and motions. But each time they pushed, Marisol pushed harder. One evening, she called me after reviewing a fresh batch of documents. Her voice was calm, but I could hear the excitement underneath. Ethan, you're going to want to hear this. In Ellison's own filing with the SEC, the preliminary 8K about the merger, they disclosed a line item about anticipated reductions in equity obligations due to pre-close headcount realignment. That's corporate speak for exactly what they did to you, and they put it in writing to the federal government. I sat in stunned silence, then laughed. They confessed to the crime while bragging to shareholders. Pretty much, Marisol said. This is bigger than just your case. If the SEC decides Arcadia misled investors, it's securities fraud. I felt that same cold satisfaction I'd tasted when I first read Section 7.3. They hadn't just wronged me. They'd built a trap around themselves. And all I had to do was hold up the mirror. The pressure on Arcadia mounted. First, a journalist from the Austin Chronicle reached out after hearing whispers about mass firings before the merger. Off the record, she asked me, were you one of the employees cut right before the acquisition? I hesitated, then gave her a single line. All I'll say is I was terminated without cause 2 weeks before close, after 6 years with the company. The next week, the headline hit. Arcadia Dynamics faces allegations of firing employees to avoid vesting liabilities. The article didn't name me, but it didn't need to. Inside Arcadia, panic spread. Shareholders began emailing the board. The story was picked up by a finance blog. What started as a personnel dispute was now a reputational firestorm. Meanwhile, Marisol kept digging. She uncovered something even more damning. In the board minutes from September, Ellison himself had warned the directors about the risk of triggering accelerated vesting provisions for senior staff. That line was underlined in red ink. And beneath it, a note. Recommendation: terminate selected employees pre-close to minimize obligations. There it was. Not just negligence, premeditation. Marisol tapped the page with her pen. This is your smoking gun, Ethan. It shows intent. No jury in Texas will side with them once they see this. I clenched my fists. 6 years of loyalty, reduced to a line item on a balance sheet. But the rage didn't consume me anymore. It steeled me. Arcadia tried to buy me out. First offer, $400,000, delivered in a polite but threatening letter. Second offer, $1.1 million, framed as generous severance to close the matter. By the third offer, $2.3 million, Ellison called Marisol directly. Tell your client he's lucky we're even offering this, he sneered. If he drags us into court, we'll bury him in motions until he runs out of money. Marisol put the call on speaker so I could hear. She didn't raise her voice. Richard, your client already buried themselves. You just haven't realized it yet. Then she hung up. I laughed for the first time in weeks. By December, the legal war was in full swing. Arcadia filed for summary judgment. Marisol filed counterclaims, wrongful termination, breach of contract, violation of Texas Labor Code Section 61, and securities fraud under federal law. The judge set a hearing for January 2025. In preparation, we deposed Arcadia executives. One after another, they sat in a conference room downtown, sweating under fluorescent lights while Marisol dismantled them. The CFO admitted under oath that part of his compensation was tied to cost savings from reduced equity obligations. The HR director stumbled when asked why my termination paperwork was dated October 2nd, but entered into the system on October 6th, after the board meeting discussing vesting.
And when it was Ellison's turn, Marisol pulled out his own SEC filing. "Mr. Ellison, can you explain why your 8K describes reductions in equity obligations as a benefit of the merger when those obligations were tied to employee contracts you were actively breaching?" Ellison's jaw tightened. "That was boilerplate language." Marisol smiled thinly. "Boilerplate fraud?" He didn't answer. For me, the hardest part wasn't the depositions or the endless paperwork. It was the waiting. Nights alone in my apartment, bills piling up, wondering if I'd bet my entire future on a legal technicality. But then I'd think about my daughter. I'd picture her asking someday why I let people walk over me, and I knew I couldn't fold. Not this time. In late December, Marisol called me with news. Her tone was measured, but I could hear the weight of it. "Ethan, I just got the judge's preliminary ruling. We beat arbitration. The court agrees the clause was unconscionable. That means we're heading to open trial, jury, public record, everything." For a moment, I couldn't speak. Then I exhaled slowly. "Good," I said. "Let them squirm under the lights." Marisol chuckled. "They're going to throw everything at us now. But remember, we have their own words, their own filings. That's more powerful than anything else." I leaned back in my chair, eyes closed, a strange calm settling over me. Arcadia thought they could erase me quietly. Instead, they had set the stage for their own humiliation, and the curtain was just about to rise. January in Austin was cold and gray when the trial began. The Travis County Courthouse loomed heavy with history, its limestone walls weathered by decades of battles like mine. I wore the same Navy suit I'd worn to board meetings back at Volt Forge. This time, though, I wasn't there to pitch a product. I was there to prove that my life's work had value, that my rights mattered. The gallery was fuller than I expected. Reporters, former employees, even a few tech bloggers sniffing for drama. The whispers filled the room. "That's the guy they fired before the merger." Judge Ramirez entered at 9 o'clock sharp, her reputation preceding her. Fair, meticulous, intolerant of arrogance. She adjusted her glasses, glanced over the docket, and nodded for counsel to begin. Arcadia's side went first. Richard Ellison strutted to the podium, all polished arrogance and expensive tailoring. He painted me as a disgruntled employee, a man clinging to fine print to extract millions he hadn't earned. "Ladies and gentlemen," he said, pacing theatrically, "this case is about entitlement." Mr. Tran was terminated because his role was redundant. That's life in business. He is now attempting to twist language into a golden parachute. He waved a hand toward me dismissively. "This is not justice. This is opportunism." I kept my face still, but inside I felt a quiet fire. Opportunism? 6 years of sweat erased with a pink slip, and he called it opportunism? When Ellison finished, Judge Ramirez turned to Marisol. She rose slowly, steady as stone. Her voice was clear, calm, but every word cut like glass. "This case is not about entitlement," she began. "It is about contracts. It is about promises made and promises broken." Mr. Tran signed an agreement with Volt Forge that included specific protections in the event of a change of control. He upheld his end. Arcadia Dynamics did not. She let that sink in, then held up a thick binder. And the irony, Your Honor, is that Arcadia documented their own misconduct. We will show you board minutes, SEC filings, and termination papers that prove beyond doubt this was a calculated move to deprive my client of what was rightfully his. Her eyes locked on Ellison. This isn't opportunism. This is justice. The evidence phase was devastating for Arcadia. First, payroll records showed my termination processed exactly 14 days before the merger closed. The timing was no coincidence. Then came the board minutes, complete with my name underlined, noting the risk of acceleration if I remained employed. Marisol introduced the 8K Ellison himself had filed with the SEC, bragging about anticipated reductions in equity obligations. Finally, she pulled out the draft HR memo, the one I'd saved, that said in plain English, headcount reduction to minimize vesting liabilities. Each piece stacked atop the last like bricks, building a wall, and Ellison could only watch as the structure rose around him, trapping his client in the prison of their own words. Cross-examination was almost cruel. Marisol asked the CFO, "Is it true your bonus was tied to reducing costs associated with equity obligations?" "Yes," he admitted, voice small. She turned to the HR director. "Is it true you backdated Mr. Tran's termination in the system?" The woman shifted uncomfortably. That was an administrative error. An error that conveniently reduced Arcadia's obligations by $4.2 million? Silence. When Ellison himself took the stand, Marisol didn't hold back. "Mr. Ellison," she said smoothly, "in your filing with the SEC, you wrote that the merger would reduce equity obligations. Did you not?" He tried to wriggle. "That was generalized language." "Generalized enough to describe firing my client to avoid contractual vesting?" He bristled. "I never said that." Marisol lifted a paper. "This is an email you authored, dated September 15th, instructing HR to clear the vesting cliff for certain employees. Mr. Tran's name is on that list. Care to explain?" The gallery murmured. Reporters scribbled furiously. Ellison's face flushed crimson. When it was my turn to testify, I kept it simple. "I gave 6 years to Volt Forge," I told the court. "I wasn't asking for charity. I was asking for the protections I negotiated in good faith. They tried to erase me to save money. But contracts mean something, and so does respect." I glanced at the jury. Some nodded. They understood. They were workers too, parents too, people who knew what it meant to be discarded by power. Closing arguments came swiftly. Ellison's final words were desperate. "If you award Mr. Tran millions, you set a dangerous precedent. Companies will fear hiring ambitious people, worried they'll be punished for making tough choices. Business requires flexibility." Marisol's rebuttal was surgical. I thought for a moment, then said simply, "It feels like justice." And justice always matters. 2 months later, I used part of the settlement to buy a modest office space downtown. I launched a consultancy called Foundry and Fair, dedicated to helping tech workers navigate contracts and fight back against corporate abuse. Within weeks, cases poured in. wrongful firings, equity clawbacks, non-competes used as weapons. We weren't just fighting for payouts. We were building something bigger, a shield for people like me who'd been treated like disposable assets. As for Arcadia Dynamics, their merger limped forward, but the scandal clung like smoke. Shareholders demanded Ellison's resignation. The CFO retired abruptly. VoltForge's founder vanished from the scene, reputation in tatters. They thought firing me was the end. Instead, it was the beginning of their unraveling. Sometimes, revenge isn't about destroying your enemies. It's about forcing them to live with the wreckage they created. Arcadia had built their empire on arrogance, and arrogance was what undid them. All I did was hold them to their own words. And that, in the end, was enough. Business requires integrity. Contracts exist precisely to prevent power from discarding people at will. If companies can rip them up whenever inconvenient, then the system collapses. This case isn't about one man. It's about every worker who's ever been told they don't matter. Today, this court can send a message that promises mean something. The courtroom was silent when she sat down. Judge Ramirez deliberated for what felt like a lifetime. Finally, she returned. Her tone was measured, but every word felt like thunder. I have reviewed the contracts, the filings, and the testimony. The evidence is clear. Mr. Tran's termination was executed with the specific intent of avoiding contractual obligations. The arbitration clause is unconscionable and void. The non-compete is unenforceable under Texas law. Therefore, I rule in favor of the plaintiff. My chest tightened. She continued, Arcadia Dynamics is ordered to honor the acceleration clause. Mr. Tran shall receive the full value of his vested equity, calculated at $4.2 million, plus damages for wrongful termination, plus attorney's fees. The gavel came down, a single strike that echoed like justice itself. The gallery erupted. Reporters rushed for the doors. Ellison sat pale, staring at the floor. The CFO buried his head in his hands. I just breathed, slow, steady. For the first time in months, I felt whole again. Outside the courthouse, cameras flashed. A reporter shoved a mic toward me. Mr. Tran, how does it feel to win?